Hello, everyone. This is Bernie Wolfsdorf, the managing partner of WR Immigration. Thank you for joining us today. I am joined today by my partner, Joey Barnett. I can now say that famous Joey Barnett, vice chair of the EB-5 committee. Joey has been suffering with me on EB-5 for approximately 10 years. I must say, this current era that we are in is probably the most exciting period we've ever experienced in the EB-5 industry. 2024 has been a phenomenal year for us with the RIA program, the new and improved EB-5 program, and the simple single reason why EB-5 is so hot right now is because of concurrent filing. Joey, say hi to everyone, and we're going to give you a 1 hour or less of information on concurrent filing. Concurrent filing is actually quite complicated, and there are even one or two questions we do not have answered. But the good news is 98% of the circumstances are not only positive, but we have already successfully filed, hold your breath, hundreds of these. And you may say, well, based on the statistics, how? But the fact of the matter is concurrent filing provides an opportunity to adjust your status in the U.S., to obtain unrestricted employment authorization, unrestricted travel authorization, and at least up till now, getting your green card without even going through an in-person interview. That, of course, may change in 2025 with the new administration. So,
Yeah, I'd say that the majority of my clients that are doing EB-5 are in the United States. They're not abroad. We certainly have some who are abroad, but I would say the majority of the people that I'm filing for are either on H-1Bs, stuck in the EB-2 or 3 backlog, or maybe students. And that's really, I think, just across, speaking with other EB-5 attorneys, I think they'd say the same. So this concurrent adjustment is huge because the RIA, the new EB-5 law, allows you to file your adjustment at the same time that you file your EB-5 petition. Previously, you had to wait for your EB-5 petition to get approved in order to file the adjustment. Now you get to file them together or concurrently, and that's the big change.
absolutely. And Joey, just to emphasize that again, in the old days, you had to wait till your 526 got approved. Now 526E, reality, but it could also just be a 526, right? This could be a direct as well. You can do concurrent filing. It's not just for regional center projects. It's all EB-5s can do concurrent filing under, and by the way, this, we won't get too legal today, but Section 245, adjustment of status. Now, in the old days, the 526 was taking many months, sometimes many years. So on the positive side now, they can file adjustment and get these ancillary benefits of work and travel permission for themselves and their families and not have to worry about non-immigrant status. So this is huge. On the negative side, because we want to look at all aspects, there are also certain risks attached to this, correct, Joey? I mean, at the end of the day, what if your 526 is denied? Or what if your adjustment is denied? Do you have appropriate underlying status? And by the way, I use a really simple analogy to explain adjustment of status. And some of my analogies are weird, I must admit. But this is Think of adjustment of status as the bridge, and the 526 is the pillar holding the bridge up. So the 526 drops. What happens to the bridge? Bingo, it falls. The first question, Joey, if the 526 drops and falls, is it possible to file a new 526 to put in a new pillar underneath that? So like your 526 gets denied, you go on appeal, you challenge it in district court, whatever you do, can you put in another one and just file a new 526 if you're within 180 days under 245? Okay.
Yeah, I think you would. Or if you were maintaining your underlying status, even during the time in which your adjustment was pending, then absolutely you would be able to, because you're maintaining that H and you have that status to adjust from. You know, I would say another thing, Bernie, is, sorry, just before you go down that, there's another pillar underneath the I-526, which is the 956F. Right. So if the project doesn't get approved too, that also will topple the 485.
Thank you for reminding me of that. And just to explain to the rookies in this group, I know a lot of you are seasoned lawyers and regional centers, but for others, Joey, thanks for reminding on that. But come on, Joey, you file quite a lot of these. All of yours get approved, but I have heard stories of 956Fs getting approved. And under the new rules, people can actually file their 526 with just proof that the 956F, which is the project, so rather than use the technical term, we just refer to the project. If the project is denied, the project approval is denied, the 956F, then all the other petitions or underlying petitions will fail. And I have heard stories of one or two of them getting rejected. So that puts all the adjustment cases in some risk. But arguably, if they still have less than 180 days of being out of status, they can put in a new 526. Would you file a new adjustment on that, Joey, or would you just try to interfile that? How would you do that? Either way, I suppose, right?
I guess I would do a new one because I don't trust USCIS to connect the dots.
Yeah. Unfortunately, folks, there's often a situation where the files just don't seem to connect. We're getting a little technical here, but I think Joey's correct, is that you can try and interfile a new 526 if the adjustment goes down, or you can simply file a new adjustment of status, give them a new filing fee, and submit a new application. All right.
So the AILA EB-5 committee just got a letter back from USCIS where we brought up all these technical issues. And one of them was the interplay between IPO and the service centers that handle the adjustments and the EADs and the advanced parole applications. And they pretty much said, hey, if you have issues with adjustments, you should deal with those service centers. We have nothing to do with it.
Got it.
And it's like, well, but on things like this, where you're changing the underlying basis or something like that, I don't know. I haven't seen good coordination personally.
Yeah, they call it transfer of underlying basis, and it's like, that's this new technical term. I just used the word interfiling. Oh, by the way, Joey, and I forgot to give you the big shout out. Joey is the current vice chair of the AILA EB-5 committee. And I've got an axe to grind with you, Mr. Vice Chair. I got kicked off the committee, but maybe it was about time to do that. Get rid of the old guys, bring in the new smart blood. But congratulations to you, Joey. The big accomplishment. I'm super proud, but it's no longer, people always, oh, this is Bernie's firm. You better start referring it all to Joey's firm, because Joey's the big shot in EB-5. Bernie's the old has-been. But I'll try and keep you entertained anyway and see how that works. So let's go with our standard legal disclaimer. This is not legal advice. If you want legal advice, send Joey a big check. Stop that, Bernie. It's not that funny. If you want legal advice, please reach out to us. That's my email address, visalaw@wolfsdorf. If you want good advice, you really want to go to Jay Barnett at wolfsdorf.com. Joey's the smart one in this group. You're going to see that in a minute or two. I'm the one who, what can I say? There we go. Joey's email address, Joey Barnett at wolfsdorf.com, or as I can now say, the famous vice chair of Ayla. Ayla has 17,000 lawyers, by the way. Most of them don't do EB-5. Some of them are on the call today. Congratulations on that, Joey. Hey, Joey, you've been doing quite a lot of speaking. You were at the California Chapters Conference like a week or two ago. That must have been
That was
beautiful up
lovely.
there in Monterey. And then
That
didn't you
was a
just
good
do some
time.
other presentation? He's all over the place. I gotta get an appointment with his secretary, even talk to him nowadays. Where was the other one, Joey?
Yeah, it was a source of funds one that Ayla put on. It was really, really good. Ron Klasko talked about the litigation that he had won the District Court of DC.
He's done some good stuff. My hat's off to Ron. He's been having a lot of success on those source of funds cases. I mean, cash is cash. The court seemed to be quite reasonable. And by the way, that all came out of our case originally. I didn't litigate it. Ira did, Kurzban.
Yeah,
The
that's
Zhang
perfect. Yeah.
case, right? Which
Yeah.
that was a case we had many years ago. And Ira litigated that. Casco's had some success. I believe that we're in the process of litigating some of those cases as well, by the way.
Well, the
Joey,
reason why EB-5 is blowing up is because of that Zong case and because of the new visa categories and because of the concurrent adjustment option, right? You put all those three together and it's a perfect storm for people in the United States who have been saving money or have equity in their home or RSUs because they've been working for these successful tech companies for the past decade but haven't been able to move forward. Like, it's a perfect opportunity for them to kind of take that next step to the green card.
I'm going to dig a little further on some of those source of funds issues that you've raised, Joey, because there's some new cool stuff in there. We were a little bit hesitant on loans, but the bottom line is loans are working, loans on IRAs and source of funds. So we'll get into some of that interesting stuff, but let's sort of focus a little bit on our main topic, adjustment of status. Now, Joey, these numbers may not be accurate, but we're talking about who's eligible. Obviously, we want clients who are in status. Ideally, we want clients who are on H and Ls because those are dual intent visas. But the reality is there are cases, lots of people, F1s, the students, F1 OPTs. And I also want to bring into, we just had an election. I don't know if you know about that, Joey. There was an election recently in America. And we're going to have a new president. And there are, correct me if I'm wrong, 1.6 million TPS, temporary protected status, people from El Salvador, Guatemala, Haiti, gosh, a lot of countries. Some of these people have been here for 25 years. These are business owners. So, Joey, a simple one-liner. Are these TPS people eligible to file for EB-5?
Yes, they are.
Good is that there are 150 to 200,000 people with this kind of status, temporary protected status. There's the Cuban, I hope I get this one right, Cuban, Nicaraguan, Haitian, and Venezuelans, 900,000 parolees, all in status. If somebody is paroled into the United States on humanitarian basis and given a work permission, can they do EB-5, Joey?
Yes, they can.
So we got 900,000 parolees. We got 1.6 million. I'll keep changing the numbers because they're close, but I don't know the exact number. So we've got 1.6 million TPS. They're going to start rolling out of status, potentially. I sadly believe the administration is going to do this. And they have a window of opportunity. Some of them own businesses. Some of them can have the ability to put 800K, and they can file a concurrent adjustment of status under TPS, get work permission, get green cards, and stay here. even though they do not have lawful non-immigrant status. So this is amazing. Now, Joey, we previously spoke about the asylees. The asylees are more complicated. We cannot adjust the asylees unless they maintained underlying status. The asylum number is crazy. I can't remember it. I think it's 2.6 million pending asylum cases. Now, those folks are not eligible to adjust as a rule unless they maintained underlying status. Some of them remained on F. Most of them do not have status. And the analysis is, well, if you can't adjust status, can you still get a green card? And the question is, there's two places to get a green card: adjust status in the US or consular process abroad at an American consulate. Now, the question is, what if you trigger a bar? So if you've been without lawful status in the United States and you were admitted on a date certain on your I-94 admission documented, and you've been out of status for more than 180 days, you're subject to a 3-year bar. And if you out of status for more than a year, when you leave, you trigger a 10-year bar. But some of these asylees do not trigger bars. Those are the people who were in status at the time they applied for asylum. And number two, they never engaged in unauthorized employment for even 1 day. If they engage in unauthorized employment for 1 day, that will trigger the unauthorized presence and subject them to 3 and 10-year bars. But asylees are also, some asylees, you have to do the analysis. You have to do a timeline analysis. Have they ever worked without permission? Were they in status at the time of taking? Those. But then, Joey, there's another issue. What if some of the money I earned, I didn't have an EAD. Let's assume that I worked for 4 months without an EAD. Is that clean money in terms of source of funds, Joey?
No, USCIS will definitely question that. IPO will say that's not lawfully obtained capital if you don't have the work authorization. The immigration work authorization.
That's an issue. If when you're doing the source of funds report, if some of the money that was earned by you when you did not have employment authorization, I've heard of cases going both ways, but I think it's pretty clear. USCIS takes the position that if you did not have work authorization at the time you were employed, that's not clean money and you're not going to pass source of funds. All right, I'm jumping all over the place. Let's brag a little bit about WR. This firm of ours is growing beautifully. We have over 10 offices. It is 150 plus. We're pretty close to 200 people. Of course, that's not all 200 people working in EB-5. But we have a large team. We have 10 offices. And I'm going to be proud and arrogant to say that our EB-5 team is as good as any out there. All right. So
we have 7. I was thinking about this the other day. We have 7 people at our firm at least that have at least 8 years of EB-5 experience.
Wow.
And that's not including you. That's you can add.
I was going to say, Joey, I mean, I'm like 30 years on my own, but we're over 100. Honest truth is, I'm so proud of this team. Sadly, EB-5 is mega complicated. I don't know why it's so complicated, but I do know that, there's a lot of money involved. People don't really want to invest $1 million and end up having a case messed up. And this stuff is complicated. So, all right, enough about how wonderful WR is, but truly I'm proud of my 2 partners and the team. Joey, the rock star. Joey, you also on the IIUSA board, right? Or advisory board, editorial board. Sorry, I got it wrong. Editorial board. I love reading those articles. Those of you who don't know who IIUSA is, join. They really have amazing information in terms of what's going on. And the IIUSA monthly bulletin is incredible. They're also incredibly important when it comes to lobbying and Congress, and that's going to become important. So what is concurrent filing. That's our big deal. It's an amazing thing. Who can benefit from it? I've been touching on some of those issues and going into the weeds on TPS, asylees, parolees. What about undocumented? No. Why not? Well, DACA kids. I forgot DACA kids. We got 500,000 DACA kids. Have you filed any DACA cases yet, Joey? You got any in the pipeline? We should. The truth is, a lot of the kids don't have the money, but some of them do. They've been here a long time. Is the Trump administration going to terminate DACA and deport 500,000 kids who came here through no fault of their own? The answer is possibly. DACA kids can also get parole, so even if they entered without inspection, the problem with the DACA kids is that if they entered without inspection, they're not eligible to file an adjustment. In order to file an adjustment, you have to be inspected or paroled. Inspected means you didn't climb under the fence or you didn't enter through the goalpost. What do I mean by through the goalpost? You have to enter at an inspection point. JFK, airport, border inspection post. If you climb across the fence, under the fence, or over the fence, or through the fence, you weren't inspected and you're not eligible. But the DACA kids who may have come in and weren't inspected can obtain advanced parole. And if you have DACA clients, you need to get them that advanced parole ASAP. Your time may be limited. And when they come back, provided they didn't trigger the bar, they're eligible to file for adjustments. So some DACA kids may benefit from EB-5. This is case-by-case determination. And there's a whole slew of folks who are becoming increasingly anxious based on the number of calls I'm getting every day. So it's a broad framework of people, in addition to, of course, people who are in lawful status. But it's interesting what Joey said, that most of these cases, Joey, the reality is that the Indian, even I was doing this calculation yesterday, even Indian EB-1 is going to take 5 or 6 years. It's so backlogged. There is no path. Even if you're a genius from India, I'm talking about like a Stanford professor, you're still going to have to wait 5 or 6 years before you can adjust based on the backlogged EB-1 numbers for India. And for China, probably similar, at least 3 or 4 years even for EB-1. So when we get to EB-2,
Yeah, part of my initial intake, the first 2 minutes, I want to know is what's your EB-2, EB-3 priority date, right? And if it's 2017 or later, it's not an option for Indians. It's just not.
it might even be 2016, Joey, for all we know, from what I can see, and maybe even some 15s, depending on where you are. The reality is, when people ask me how long is the current waiting line for Indian EB-2, so just to translate this into English for non-immigration people, you're a graduate of Stanford with a master's in computer science. You come from India. How long is the green card waiting line? Somewhere between 30 and 50 years. That was not a typo. Maybe longer. So these employment categories, and there's basically only 2 paths for Indian national, because most people are not EB-1 anyway. EB-1 standard is really high. And that is good faith marriage to an American citizen or EB-5. That's it. If you're an Indian national, no matter how smart you are or capable you are, and Joey, I think you told me that more than half your clients fall in that category, correct?
Well over 80% at this time, and for the past 2 years. I mean, this concurrent filing has opened that door. You don't have to wait the 10 months, 16 months it takes for I-526 to get adjudicated. right now.
And we're going to talk about that. It's not only, you mentioned in your PowerPoint that, well, they can seek unlimited employment, but it's better than that. They can seek unlimited employment or no employment or start their own business or start 10 businesses or, quite frankly, retire.
And you could actually do it for, a partial investment too, if you really think about it. I mean, I don't know how I went down that path,
We're
but
going to go into that. I don't like partial
yeah.
investment, but I guess the reality is the statute's pretty clear. If you have invested or are in the process of, that language is quite clear, but USCIS doesn't always like that. They want to see that you've identified all the capital and that you are in the process of transferring it. You got to, I mean, if you don't have all your money invested by the time they adjudicate it, you're probably in trouble, right, Joey?
Absolutely, yeah. If an RFE comes and say, "Hey, you've only put in 400K, where's the other 400K?" The RFE response should say, "Oh, here it is. It's been invested."
Well, I'm a jerk on that issue. I like to have the full amount invested at the time of filing because that way I just know, we're like all gung-ho about concurrent filing, but we are going to try and be realistic. There's one thing worse, bad about concurrent filing, and that is if your petition gets denied or the project gets denied and you don't have underlying status, Joey, can you appeal the denial of a 485? I'm going to go one step further. Can you appeal a discretionary denial of a 485? Matter of Patel.
If they issue an NTA and you're put in removal proceedings, at that point you can. If you challenge it in federal court, what the government seems to be doing is saying, no, it's discretionary. There's no jurisdiction, and that's the Supreme Court decision you just mentioned.
Yeah, Matter of Patel is a Supreme Court decision, I believe, last year, right? Or
maybe
20
2 years ago. Yes,
2 years or 23. But it's basically said that, and I think it's important for lawyers to understand this, that this is a discretionary benefit, and you can't challenge them in court. Discretionary denial. Of course, there's some parameters here, but you're not going to win on an adjustment other than what Joey said, is you get your second bite at the apple in front of a judge, but the same 245 rules apply in front of the judge. So if the petition is wrongfully denied, yeah, you may win, but these status issues are important. So where are the investors coming from? We have another chart on this. Look, the majority of investors are still from China, twice as many. So China is still obviously where most of the wealth is. The number of Indian investors is really going through the roof. And then ROW, rest of the world, the drop in the bucket, right? Nothing. There isn't. Vietnam, Korea, Taiwan, Hong Kong, Nigeria, Brazil, none of them even add up combined to match number two, right? The three, the rest of the world numbers are relatively small, correct?
They are, compared to India and certainly compared to China. The issue that we have with the rest of the world and these sort of small annual visa limits for these reserve categories, they still will impact that though, because there will be that's what we talk about with our Charlie.
No. You hit a very good point, and I'm going to drill down on it. Joey, I didn't understand this one, and I still don't understand it. So help me. By the way, most of you probably know Charlie Oppenheim and Joey do a monthly show. When is the next Chatting with Charlie EB-5, Joey?
We're recording it later today, and it's going to be pushed out next week. And we're talking about this specific issue.
Okay, so let's use this as a teaser then. Joey does this show every month called Chatting with Charlie, CWC, Chatting with Charlie, EB-5. This is the source. Those of you who don't know Charlie Oppenheim, oh my gosh, why are you even here? Charlie Oppenheim was the director of visa control for the United States Department of State for 23 years. He is the only person, in my opinion, who truly understands the visa bulletin, is Charlie Oppenheim. He is the director of visa consulting at WR. Joey and him do a show every month. Please watch that. So Joey, explain this to me. China and India clearly are exceeding their 7%. That's not an issue. And there's going to be a backlog. We're going to get into that later. When does the backlog occur? I think Charlie said we're okay for the next few months, possibly all the way through till October or November, but Charlie doesn't actually know. It could be earlier. I personally think it will be earlier. The truth is we're already at the 7%, but the only reason why we haven't got a final action date or cutoff date is the delay in processing. The number of cases filed clearly is enough to use up the China and India quota, and rest of the world will also be impacted. That is going to happen in 2025. Sometimes I'm wrong, not often. So there's a window of opportunity right now for EB-5 investors. You should be going for it full bore, 100 miles an hour, put your foot on the pedal, because you're not going to be able to do concurrent filing once there's a final action date. It's going to be like the old days. You have to wait until not only don't have to wait till your 526 is approved, but you have to wait until your number comes up under Chart A, final action date, or briefly under Chart B, date for filing. And that usually is only a narrow window, October, November, December. And if they wanted to be mean, they might not even open that Chart B for filing, but they should. So,
well, what's going to happen is that these people who are filing today and in the next 6 months or so, in particular for high unemployment area, it's going to be a lot like the India EB-2 who filed, with the 2013 adjustment of status, or 2014, where they have the pending adjustment. They can continue to extend their EADs and their advanced paroles, and they're waiting for their priority date to become current, right? But they're able to remain here and work with the EAD. And so that's kind of the situation that I think we're going to see a lot for EB-5 investors.
And I argue that the combo card, which is the 5-year work and travel card, I call it the red card. The red combo card is as good or better than the green card, because potentially from a tax point of view. Now, I'm not a tax lawyer, nor am I going to give tax advice, but technically this person with an EB-5 could also be running their business back home. They may be spending less than 6 months a year in the US, running their company in India and China, coming to the US 2 or 3 times a year for a few months at a time, maybe starting a business here, kids are here. But again, I'm not a tax lawyer, but it might be able to argue because they do not have a green card. Once you have a green card, folks, you're taxable on worldwide income. So even if you get your green card on December 31, don't enter on December 31, enter on January 2, because you're taxable for the entire year because you spend 1 day in the US as a green card holder. But when you have a combo card and you're waiting for your green card, well, you're not automatically taxable on worldwide income. Of course, I said I'm not going to get into tax, but physical presence is a big issue and closer connections.
I'll say this about the red card, the combo card.
Yep.
One, the change in the sustainment requirement actually does make the issuance of the conditional green card matter less, because you can get your money back quicker now. Before, you had to wait to have 2 years of conditional green card status. So it did really impact, now it did impact when you could get your money back. Now that's less of an issue. The other thing that we're seeing with these
But Joey, I want to stop before you even get into that and not go into the weeds, because you open this issue of sustainment. I mean, yeah, but realistically, the period of sustainment is not only the legal period of sustainment, it's also what is the contractual period of sustainment, number one. And then there's a second one. Does the regional center have the ability to repay if there is no event that, Joey, I know you're a super rich guy, but you couldn't come up with $1 million overnight. You have to liquidate assets. You'd have to sell your home and your children probably in order to come up with $1 million. Even though you're so rich. I'm talking about myself, of course. But the point of the matter is that, these regional centers and projects, they don't have millions of dollars of cash. They're businesses. They need a liquidity event, right? And if you don't have a
Absolutely.
liquidity event, how many people have $1 million in the bank besides Joey? I'm I'm referring to your bonus, of course, Joey. Um,
Oh,
good.
well, I was assuming that that was the case. I'm just saying from the legal immigration requirements, it does make things a little bit more bearable, having to be stuck in a backlog. But I hear what you're saying loud and clear, Bernie. And that's, every project is different and you have to do your due diligence as an investor and we could talk for hours on that. The other thing though is there's no real rhyme or reason on some of these combo cards on when they come and the processing times. I mean, I got 4 yesterday. 2 of them were a combo card. 2 of them were not. So it was just an EAD.
Mm.
2 of them had filings in September, early September. One had it early July and one had March. So it's like the processing times are all over the place. Like I don't even know, what to say. I used to say 3 to 4 months, and we are in some circumstances, but now I'm saying they're kind of coming closer, maybe, I don't know, 6 months, 7 months. And this is one of the things that, people talk about with, how is the Trump administration going to impact EB-5? I don't think EB-5 is in the crosshairs necessarily, with their administration, but, the last time there was that everything slowed down, right? And I could see this being a place where they reallocate resources. Maybe the EADs and APs start slowing down a little bit. I don't know, just something I'm expressing to
The
clients
reality,
of
Joey, I'm getting this
consider.
question every day from investors. The reality is we don't
Yeah.
know, but what we do know is that the focus is undocumented people. And, there's one thing very clear about EB-5. These people bring capital, in many instances, foreign direct investment. These people do make jobs. We can debate about how many jobs. Is it thousands? Is it hundreds? But what part of the EB-5 program? I mean, I understand this thing messaged well. We don't want to let in 900,000 parolees. I'm going to just call war-torn areas terrible scenarios. But the simple reality is these people are coming into the U.S. lawfully, bringing jobs, creating jobs. By the way, the U.S. need for unskilled labor, and I don't even know if most of these people are unskilled or skilled. I just had one yesterday at TPS. She's a woman with like 4 years of medical school at Venezuela. These are like sophisticated people. These are fallen to best and brightest. But they are fulfilling critical jobs. This woman, I shouldn't really say, but she's working as a nanny. And, gosh, how lucky those parents are to have a nanny of that caliber. And America keeps forgetting we need unskilled labor because, sadly, a lot of Americans don't want to change bed sheets or clean toilets or pick strawberries. So, we have less than 4% unemployment. All right, Bernie, stay off your political high horse. Let's go back to the facts. We had a lot to cover. By the way, folks, in the chat column, I think if it's activated, you can ask questions. If I don't use up all the time, we'll get to answer them. And, you can always email Joey and me, Bernard at Wolfsdorf, for an intelligent answer, Joey Barnett at wolfsdorf.com. Okay, Joey.
Oh, we have 2 really good questions here, that are in the chat. All right, this one's from Ed Bashara. Besides
Who is
entering,
Ed Bashara? I've never heard of that guy before. There's some guy down in Miami. Hey, Ed, nice to hear
Orlando.
from you, buddy. What?
He says, besides entering under H or L, how much time needs to pass before a non-immigrant can file adjustment or
We'll get to
status?
that question later. Thanks, Ed. Next
Oh,
question.
okay, that's a very common
Yeah, we
question.
do
All right,
get
hit
'em
another.
back. We
And
get
there's
'em.
another. Okay, and then the other common question is, concurrent filing before 21, avoid the age out problem.
Hey, why are people asking all these complicated questions? Yeah, we're going to get into the age out issue as well. All I can say is USCIS published a memo which says Chart B freezes. Joey's going to litigate it if necessary. But in my opinion, once you file an adjustment, the kid's age is frozen. USCIS has spoken. The problem, and why this is so critical, is the State Department has taken an opposite position on exactly the same facts, which sucks. But USCIS protection is there. Joey is not as strident on this as I am, because there's still some confusing language in the statute and the regs and blah, blah, blah. But USCIS has spoken. They've said it's frozen. I'd love to litigate that one. Joey, let's dive into this rural versus high unemployment, because we're still on the roadmap and I'm worried about running out of time. Does rural, by the way, we're doing this sort of discussion thing. I've never listened to Joe Rogan, but I hear he's popular, so I've got to start listening to Joe Rogan and learn about this new format of chat, and throw in a few useful points and hopefully keep you guys slightly entertained. Rural versus high unemployment concurrent. Joey, what do you tell people? Which one is better? Clearly, rural gets 20% of the allocation, 10% gets, high unemployment gets 10%, and infrastructure gets 2%. Do we recommend
So
rural clearly twice as many visas? Some people prefer. What's your comment? Your one-liner on this?
I would say this, rural versus high unemployment does not impact how quickly you get your EAD or your advanced parole. It will impact how quickly they adjudicate your I-526, and it will impact how quickly you get the conditional green card.
Because rural is allegedly priority processing. I'm not quite sure what that means yet, but that's what it says in the statute. And the other thing is really important to understand. If you look at the visa bulletin, if you haven't seen the visa bulletin, please Google visa bulletin now. I'll explain it to you. So you have rural cutoff dates, you have high unemployment cutoff dates, and you have infrastructure. So there's three separate categories. And every possibility is that those dates are going to be different, right, Joey? That the rural is going to be better than the high unemployment when it comes to moving the line, because quite simply, they have 100% more visas with 20 versus 10. So rural is going to be better on the visa bulletin than high unemployment, is my prediction. Do you buy that, Joey?
That's what the data shows, no doubt about it. The point that I tell folks is that the opportunity that you have today, you still get that benefit whether you go high unemployment or rural. The question is how long are you willing to wait for the green card, and are you willing to take potentially a longer wait in order to secure something else that you see in a high unemployment project that you don't see in a rural, right? Because that's really
So
what
if you
it comes
really
down
like
to.
this high unemployment, and interestingly, the market seems to have preferred high unemployment up till now, or maybe there were just more high unemployment projects in the market because rural is relatively new in the beneficiary. So all the old projects got recycled, and there were more choice starting off, or maybe more attractive. We're not going to because
It's a little bit of both. Yeah, I think
Yeah.
it's a little bit of both. Yeah.
because we file both, we're not going to want to upset our rural regional centers or rural projects or high unemployment. So we're not going to back one or the other in this call, at least. But clearly, rural has some advantages. So, Joey, this is the statute. This is something you pulled off the internet. What is USCIS website? Is really pretty good.
This is from the Q&A that is in USCIS's website, very clearly saying that you can do the concurrent filing at the same time, and that's because it is current under the visa bulletin right now.
245N. So that's a new one. We've got 245A, 245C, 245I, 245K, which allows people who've been out of status for up to 180 days or worked without permission for up to 180 days to file. That's also new, Joey. 245K. They can file an adjustment. So it's not only somebody, and I hate using the word illegal because I prefer the word undocumented, but here's the simple bottom line. Somebody can work without permission for 180 days. It's not up to, it's up to and including 180, right, Joey? I had to check that once. So I've got 180 days of unauthorized employment. My tourist visa expired 180 days ago, and my adjustment got received on the 180th day. I filed a 526E and a 485. I am, let's use the horrible word, illegal alien. I came on a tourist visa to visit Mickey Mouse. I fell in love with Los Angeles. Gosh, the weather we got here, Joey, you can't not fall in love with it. It's like crazy good. And I overstayed by 180 days. I worked without permission during this period, and I can still file an adjustment under 245N for Nancy and using 245K. Correct, Joey?
Absolutely.
But there are
I was gonna say, I have a couple clients right now where they've been laid off, right? H-1B layoff.
wow.
And they get the 60-day grace period, but maybe they aren't able to find someone to go to, and now they're past that 60-day period. They're still eligible to do an adjustment because of 245K.
And they are a big source. Have you been laid off from your H-1B employer? Do you have enough money in your IRA account? Joey, I'm going to ask you about that one too if we have time. So, who can benefit? There we go. Backup plan if layoffs, or even if not layoffs. Child age out. So you're sitting with your EB2 or EB3 and it's not current. Your kid is getting perilously close. Joey, I know you're a little more conservative than me sometimes, but here's the bottom line. My kid's turning 21 on Monday next week. We've got 3 days to go. If I file an adjustment one day before my kid turns 25, according to
21.
USCIS pronouncement, the kid's age is frozen, correct?
Correct. Once the I-526 is approved.
I'm going to
it's
give you a
frozen.
sexier one, which you may or may not know the answer to. My kid is aging out, or my stepkid is aging out, and that kid is still in China at college, or in Taiwan in college. So they're not in the US. If I file my adjustment together with an 824 following to join petition, does that or does that not freeze the kid's age? My answer is it does, right? But agree with me? This is not a legal opinion. You cannot sue me, but there are several situations, folks. The filing of 485 locks the age, and the filing of a 485 together with an 824 following to join also locks the age of the derivative, according to my calculation. But don't sue me on that one. Call me, and we'll be happy to talk about whether you could pick up a derivative. It's a unique situation. So, Joey, we spoke about bullet 3, new employment opportunities with EAD. I broadened that to say, I'm rich. I don't want to work. I want to, hey, Joey, I started playing crypto a little bit about a year or two ago, and my wife told me how stupid I am. She tells me that every day.
Me too. They got that too. Well, not your wife, my wife.
Oh, well, your wife probably says that about me too, but the point of the matter is my crypto went crazy yesterday. I've like doubled my money. And she said, it has no value. It could drop overnight. Yeah, but Trump's going for crypto and the whole world's now going for crypto. Crypto's hit like 60. I don't remember. I'm not that good at crypto. All I know is it went through the frickin' roof yesterday and I like doubled. Because I'm poor, I didn't put that much into it. But Joey, take your bonus and put it in crypto and you'll probably find it all collapses next week. But whatever. The bottom line is,
hey, we got a question from Kevin Wright that
hey, my buddy Kevin. Hey, Kevin, how's it going in Florida? I gotta tell you, Kevin's been my buddy for years and years and years, and he understands this program, and I have a big shout out to Kevin. What's Kevin have to say?
He wants to know, what do you think is going to happen to EB-5 if Trump gives foreign college graduates green cards? And the reason I'm even, it's a hype. I just want to know, do you think that's going to happen, Bernie?
Joey, Kevin, I know, look, Donald Trump, you do have to listen to what he says because he does a lot of it, but he will tell different audiences different things. This comes from Andy Grove, the former CEO, founder of Intel. We should pin a green card on all these PhDs. You know, folks, What Trump says is less important to me, quite frankly, than what Stephen Miller says. He's our new Deputy Chief of Staff for Domestic Affairs, very powerful. He's the guy running the show. And Stephen Miller said we should scrap F1, OPT, and the H1B. That's what Stephen Miller's saying. Now, I've seen that tweet. It was done in 2021. Scrap, I pray he doesn't. And Congress would have to act on that. But this idea that they're going to give out green cards to all international students, there are, let's get the numbers right, 300,000 Indian students in the US, 200,000, 250,000 Chinese, 500,000. He's just going to give out green cards to all of them. Yes. Ha, ha, ha. That's a funny, funny joke. Sorry, Kevin, I got to give you my answer. It's ha, ha, ha. Was that a funny joke? I know you have a good sense of humor, Kevin, but that was the funniest thing I've heard all day, because they are not going to give out green cards. And I'll go one step further. There was a bill put in Congress to give all our STEM PhD geniuses, the guys who are at the cutting edge of science, green cards, and the Senate turned it down last year. I mean, come on. This is our best and brightest PhDs. They don't want to give them green cards. So the chances of this administration giving out free green cards to all students is about the same as a meteorite hitting me on the head right now. Bang. Okay, so much for that one. Students on OPT not chosen for the H1. Joey, it's bigger than students on OPT not chosen for H1B lottery. By the way, the H1B lottery last year was much better than previously. But the statistics are still 25% for bachelors and maybe 30, 35 for a master's. They get 2 shots. Folks, you really want a lottery? You know, rely on H1B? And you know what else they're going to do to the H1B program, Joey? People don't get this. The biggest problem is not just the lottery. The fact that your chances of getting selected suck. 30% best of getting selected is they're going to change the prevailing wage framework for H1B. That's not hypothetical. It's proposed. They're going to finalize it, and they're going to increase the H1Bs are required to be paid a prevailing wage, which is a median wage. They're going to push that up minimum of 35 to 40%. So to sponsor someone on an H1B, you're going to have to pay some kind of insane salary. Really? Employers are going to do that? Okay, let's see. They don't, and they won't. And it's a huge problem. So even if they don't kill the H1B program, they're going to stifle it and make it so difficult via the DOL. Temporary protected status, we already talked about it. 1.6 million TPS folks. Some of these guys have been here since the 90s, 25, 30 years, extending their TPS. They may have started off working in the kitchen, now they own the restaurants. And they're owning the construction companies. And they're owning lots of businesses. I don't know what D stands for, but let's forget about that. Here's the facts, folks. So far, under this program, 1,400, and it's more than this, Chinese folks chargeable to China. Approximately 1,500 Chinese. Half of their numbers for India, about half, 800 have filed. Total of 3,000 cases. When you think of 7% in the overall numbers and what the waiting line is, by the way, Joey, we stole this from Suzanne's blog, so we need to give her credit here. If this came from Suzanne, she's a great friend of ours. And by the way, I actually think her blog's the best blog in the industry, other than yours. But for those of you who don't follow, you agree with me, right, Joey?
It's required reading.
It's required reading. So if you want to be an EB-5, go and read Suzanne's blog. She's a friend of ours. She does awesome stuff. She's a business plan writer. You notice I give lots of credit to everybody, but seriously, it's required reading. Joey says it in one word, and I say 100 words which say nothing. Infrastructure 0. I don't think this is accurate, Joey. I'm sure we filed the infrastructure project already, but I'm not commenting on that.
These are just adjustments. And so these aren't,
Oh, wow.
they're just adjustments.
All right.
And
So that explains
so it's-
to me, Joey, because
Yes.
I think 6,500, 7,000 people have filed, and your numbers are only showing like 5,000, right?
Exactly. So I'm just saying the number of it's still significant though. Even if there were 2 adjustments per I-526 or 2.5, it's still significant
And
because I think
this
there's
counts
only,
not just petitions, right? So now we're counting heads. We're counting. So for the number of petitions, you would divide this by 2.5, right? Or 3 or something.
Exactly.
So the number of petitions filed is much less than the 5,000. It's only like about 2,000. But
So
some people like
it's
Joey,
2,000 of the 5,400. That's almost half, right? I mean, that's half. That's what this is saying. It's a lot.
But just
It's a
remember,
significant
like
amount.
Joey has 2 kids and a spouse, so he would be a 3-to-1. I have 4 kids, by the way.
4-to-1. 4-to-1.
4-to-1. 4-to-1. So I
Yeah,
would be even
yeah.
more. I got to take my shoes off because I'm going past 10. I can't count. I had to become a lawyer. So, okay. Nevertheless, those numbers are pretty good, but what's the takeaway here? The takeaway is twice as many people chose high unemployment versus rural, approximately, correct?
Exactly. Through July 2024. Yeah.
So that
Exactly.
means that the high unemployment traffic jam is going to be pretty bad when the numbers
The line is longer. The line is longer for
when people
unemployment than
finally
rural.
get to adjudicate these cases, which, hopefully, I'll probably be retired or buried by then. Stop that, Benny. But Joey, you'll have to finish these cases because, how long will these adjustments take? Okay. Does rural versus high unemployment, concurrent filing? So the bottom line here, Joey, and this is the big one, is once the final action date is established, that's chart A, your 526 has to be filed before that date. Unless for that month, which would probably be October, November, December of 25, if you get lucky, they allow chart B filings. So they normally only allow chart B filings for like 2 or 3 months at the beginning of the immigration fiscal year when the new supply of visas comes on the market. So is that why Charlie is saying we may be open till October, November of 25?
Yep, exactly. And really the reason why is because USCIS hasn't adjudicated enough of these I-526s to create the quote unquote demand the Department of State needs to see in order to establish the final action date.
And we don't have so-called visibility, as Charlie likes to say, right? So,
yeah, because there could be to the bills, right? I mean, yeah, they don't.
What if 80% of these cases get denied? Then actually we don't have a waiting line problem, right? But the reality is, Joey, just talking about approval statistics, not in this chart, but others I've seen, the approval rates have been running like in the 90 percentile on these.
Yeah.
And now even your loan cases are getting approved, correct? Something I was nervous about, but they're starting to get approved. So, Joey, we're running out of time because I talk too much, but just briefly in 15 seconds, tell me, I'm working on an H-1B. I've got an IRA. I don't want to cash the thing in. There's going to be penalties. How do I leverage that for my source of funds?
Right. So one of the more recent developments is using this self-directed IRA. Pretty much what people are doing, they are rolling over the funds in their 401k into a self-directed IRA. And that self-directed IRA, it's sort of a custodian account that invests on behalf of the investor into the NCE. And this money is lawfully obtained. It came from their 401k. And pretty much there needs to be this self-directed IRA custodian that signs off on the transfer of funds into the NCE. And then, of course,
language with
I don't know. To me, it made sense. I guess I was getting.
You're a guru. Don't put it into like Dumbo language.
Pretty
So
much, if you have 401k, you can take a distribution and get tax penalty. You can get a 401k loan and take 50k out, or you can use the full balance and roll it over into a self-directed IRA. And rather than waiting for using the money in your 401k to grow in traditional investments, you're putting the money into an EB-5 investment.
How do you feel? Sorry, I'm going to put you on the spot here. How do you feel about the RC actually being the entity that's financing this thing? Because is that going to be okay?
That is a separate loan program. Well, the self-directed IRA is not a loan. It's
Correct.
another recent development is a regional center entity affiliate providing financing to EB-5 investors to sort of lower the barrier of entry. They'll give a 300K loan, the investor puts the other 500K in, and the full 800K goes in. And, the question becomes, well, the lender, how did they earn that money? And is this a bona fide real loan, right?
Full source of funds report on the lender.
Yeah, you should.
But the bottom line is they actually have approved some of those cases as well, correct?
That's what we are saying. Yeah. Yeah. I mean, the unsecured loans that I've got a number of approvals for that, where a friend, got a bonus and they're lending, the EB-5 investor 40K to fill out the balance of the 800K. That's no problem. There's a loan agreement. You show where the money came, show the bank statements. You're good to go.
So
This is
Joey,
something that I get asked every day. And, this is part of the questions that someone asked before. It's like, well, how long do you need to wait? And this is something that I'm paranoid about, in particular because of Stephen Miller, because it doesn't matter how long, as far as I'm concerned, and what the policy manual says. If you came in on a visitor visa with an intent to adjust, it doesn't matter how long you wait to file. That's how I read the policy
So
manual.
Joey, I've trained our junior lawyers conservatively on this issue, but the real question is, what was the person's intent? And I always talk about gardening. Did you pull up your roots in your home country? And did you plant your roots? Did you plant your feet in the US? And when did you do it? So when did you take the kids out of school? When did you open up a bank account? When did you? So what if, Joey, you signed your subscription agreement before you enter on a tourist visa? Is that evidence of preconceived? I don't know why they call it preconceived intent. It's just intent to file for a green card. And by the way, it's visa fraud. And by the way, the consequence is 212A6. And by the way, that's a 99-year bar. Unless you can get a waiver, good luck on that. So visa fraud may be the tool that Stephen Miller uses to hit these people over the head. And Joey, we've seen it when they travel on advance parole. They come back in on their advance parole and they say, oh, when you entered on a tourist visa, did you have an intent
Yes, they've done
to
that.
file? And they take him in a little room and they've been on a 20-hour flight and their brain is mush and they say yes. And that's in the record. And by the way, folks, they've been approving these adjustments. We got quite a few adjustments approved already with no interview. We expect the interview waivers to go. So people filing concurrent are going to need attorney representation. Those of you doing DIY, do it yourself, stop. Hire Joey or me or any of the other lawyers on the thing. Just be careful of Ed Bashara. He's super smart. No, I'm joking. Ed's my buddy and he's a good lawyer. So, simple bottom line. Ed, send me the check for saying that, please. So, let's take it statistically. If you come on a tourist visa and you have intent to file an adjustment, that could be visa fraud. There was something called 30, 60, 90-day. US has scrapped that. They said totality of circumstances. So maybe there's no 30, 60, 90-day rule. I think to be safe, because the State Department still has these guidelines, 60-day guidelines, don't file within 90 days. And you better be clear on what it is that caused you to change your mind. For me, clients consult with me and I tell them, are you aware of concurrent filing? They say no. I say, well, it's the greatest thing since sliced bread. They say, lovely. That point, they did not have preconceived, but if they took their kids out of school and they opened bank account, that's not what tourists normally do. So, this is a detailed analysis. Most lawyers know it. Please be careful, because if they get hit with visa fraud, they're going to be very unhappy. And that's a lifetime bar. And You're not going to adjust even in removal proceeding. When to use an EAD? Oh, Joey, that's such a complicated thing. So, Joey, your point here is that if you're on an F1 and you use an EAD, you're kind of killing your F1 student status. Is that it?
Exactly. It's about maintaining your underlying non-immigrant visa status.
But it's not a problem on the H or L because of the Cronin memo, right?
In terms of travel, yes.
What about if you're
Yes.
from Australia, not where you have a lot of Australians, and you're on an E3 or a TN or a TD, those NAFTA visas, Singaporean H1B1, which is not dual intent, or Chilean H1B1, those guys, if they don't benefit from the Cronin memo, right?
Right. So
That's the Cronin memo, folks. May 25, 2000.
yeah, and it talks about the dual intent for adjustments. And I guess the question or what I always am talking with clients about is you want to maintain your non-immigrant visa status, because if your adjustment is denied, then what are you going to do? You're not here you don't have any status. And so sort of I don't know, the conservative, some people can't wait to use their EAD. And that's why they're doing this, right? They want to get away from their H-1B employer. But a lot of folks are doing it as a backup plan, or maybe you wait till your I-526E is approved before you use your EAD.
Now,
Because then
that's
you have a good feeling, like, why else would they deny your adjustment if your I-526 has been approved?
well, you
right?
could be a
So-
communist.
Well, exactly. There's those sort of inadmissibility things or criminal issues or past immigration violations. But if those are clean, then you should feel reasonably confident that your adjustment is going to get approved once your I-526 has been approved.
What about all my shoplifting convictions? I have 2 of those. I'm out, right? 2 shoplifting
Mhm.
convictions. How about DUI? I have 1 DUI. Am I okay, Joey? Yes. How about if I like smoking pot all day? Does that make me inadmissible, Joe? Here in
Mhm.
California, it's legal, right? No,
Doesn't
no,
matter.
no. Pot is not legal in America, folks. Not for immigrants. Only for Americans. Not even for green card holders. Technically, green card holder, there could be a basis. I don't want to get into the weeds on that. Ha ha. Good pun, eh, Joey? I'm not getting into the
Nice.
weeds. Ha ha ha. So funny. So, Joey, what you're telling me is that maintaining underlying status till your 526 gets approved makes a lot of sense. Smoking weed does not make sense, and it can make you all fuzzy and confused. Yeah, so 485 is kind of fragile. There's grounds of inadmissibility. Joey, I don't know.
So just the point that I wanted to kind of make was, like, with this preconceived intent and the discretionary element of it, and who knows what happens with Stephen Miller. I think people just kind of need to have the full picture before they decide what to do. And I don't know. The opportunity is there and people want to take advantage of it. They don't want to wait outside the United States to do EB-5, right? They don't want to wait to do
Yeah, but
consular
Joey, you
processing.
can't counsel them to come in on a tourist visa and file an
I know. I'm just saying that happens. It's part of my daily conversation. I'm sure other immigration attorneys as well on the call.
Yeah,
usually
I know.
says,
If somebody calls me from abroad and says I want to sign up and I'm going to come on a tourist visa, you can't do that, lawyers or anybody. Advise people to come on a tourist visa with a plan to file for adjustment. That's visa fraud, and that could lead to a disaster. By the way, those are all of our offices all over. We've got kind of big, but other than Joey and me, the 3 partners, Vivian Zhu, of course, is our other partner and our growing team. Joey, I think we're kind of out of time, and probably people got a headache from me talking so much. I hope
people stayed on.
all of you learned a few things. Please feel free to reach out to Jay Barnett at Wolfsdorf, and watch for Joey's Chatting with Charlie so we understand where we're going with this. So thank you, everybody, for joining us today. Joey, thanks for putting this all together. I hope some of
Thank
you
you,
learned
Bernie.
something. Kevin writes, stay out of trouble. Come and visit me next time you're in LA. And thank you for all you've done. Ed, look forward to seeing you, my buddy. Appreciate how diligent you are. A lot of immigration lawyers on this call. I don't know if David Herson's there. he registered as well, but I'm very honored that smart lawyers care to listen to what Joey has to say. So on that cheery note, have a good one, everybody.